Let's now speak to Tebogo Khaas, who is the Public Interest SA founder and chair. Thank you so much for your time this afternoon. At the face of it, a lot appears to have gone wrong here, does it not?
Absolutely so. There seems to be quite a lot of questionable conduct on the part of the former employees, as well as on the part of Reuters, Thomson Reuters itself. There seems to be lapses in terms of internal controls, or maybe not so much lapses because the people who are responsible for managing the procurement processes themselves are the ones who found themselves in the midst of all this unpleasant procurement event.
And does the timing of their departure mean the last day in office is the 31st of May? On the 1st, you are now working for the company that is a local partner to one that has just bagged a lucrative contract. Does that timing also raise suspicion?
It certainly does. And especially because now they're trying to spin it and say they were not involved in negotiations with Thomson Reuters while they were still in the employ of the OCJ. And it just doesn't make sense that you could leave your current employer today and go and be joined. Let's say, for example, would you leave your current employer to go and join the other broadcaster the following day without having had negotiations with the other guys? No, It just doesn't happen like that. And the same here, you cannot be that you are responsible for setting up the tender process and adjudicate over it and have oversight, and then the following day after you've left, go be a beneficiary of the same tender that you are responsible for putting together and adjudicating on, and tell us that no, you never had any discussions with the other people. You just basically you just happen. It just doesn't make sense. It just doesn't add up. And there's quite a lot of things that also put a lot of questions. For example, for starters, they claim that they went on a single source procurement process because there was nobody in South Africa, locally or anywhere else, who could provide the same software solution or platform that Thomson Reuters has. When in fact, just the desktop search that we conducted yesterday, less than 30 minutes, we unearthed more than 20 companies globally that does exactly what Thomson Reuters platform does for courts, for court management systems. And then you ask yourself why. So in other words, the premise itself was fraudulent insofar as deviation from procurement processes. It was fraudulent because they circumvented the open procurement tendering process where there'd be competitive bids, and therefore the state would stand to benefit by way of making sure that prospective suppliers get to compete on pricing, quality, and many other things that got to be considered when tenders are adjudicated. So it is just on that basis we say just doesn't cut it. In fact, the Office of the Chief Justice as a department ought to move quickly to actually look to cancelling this. I'm sure the legal advisors are busy at looking at that, but it's no brainer. And it is very sad because we're coming just at the throes of state capture and involving multinationals who seem to come here like the Bains of this world, McKinsey's, who come here, pick up a few unscrupulous senior employees in state or in government or even outside, and enable that corruption, and which is what we believe is happening here.
And also at the same time, this very company saying that it did not plan to subcontract and was told weeks later, should this not have been information that was put very clearly in the specifications of the tender right from the beginning?
Absolutely. I can't remember what the provision, the section that provides for that is in the preferential procurement policy framework is, but certainly it does deal with subcontracting, that when you go out on tender that exceeds 30 million rands, you must ensure that 30% of that gets to be set aside for small businesses, SMEs or EMEs as they say it, or qualifying enterprises. And you also subject them, whoever it is the recipient of the tender, ought to subject these SMEs to a selection process of sorts. And based on that process itself will take some time. It's just something that happens overnight. Then you'll be able to select the right people. Now you tell me, an accountant, a spokesperson, I can't remember what other role the other guy was doing, would there be people who are so competent technically in the IT space to outbid any other potential supplier? And in any event, what happened to the people that they actually were doing a pilot project with? Are they suddenly not good enough? I mean, they talk about the other company, Tirisan. Are they suddenly not good enough for you to do that? So that on its own seems to be a transgression. And Thomson says they didn't know. But it is part of the tender bid documents upfront that tells you that you need to be able to subcontract, and you should know that your pricing is going to be more than 30 million. So in other words, you should start lining up potential SMEs that you're going to work with. In fact, in some instances, they ask you to provide a list or identify an SME that you'll be working with. It didn't happen.
Pardon me. I'm keen to find out what the regulations also say, though, about the cooling off period, particularly for senior officials who are leaving a department and then immediately doing the business with that very department. There are laws that look at this cooling off period.
I'm not sure if the DPSA has brought those or enforced it. We've seen it happen with the Reserve Bank governors who have left the employ of the Reserve of Government to go and run banks, the very same entities that they were regulating, within 6 months. Some just for vanity purposes, 6 months later. But it's also neither here nor there. But to the extent that they just didn't do it, just raises flags itself. It just told you that they had an intent to benefit. So whether it was 6 months later or less than 6 months, they had an intent to benefit, because all this, they seem to have paved it for themselves. Because Thomson says they were only told a week before adjudication, before award, that they actually needed partners. So you just tell them. So it means they were preparing the bait for themselves.
And you have now written, of course, to the Office of the Chief Justice and calling for, the suspension of performance here. Let's see if, these investigations yield any result at all, as they say that they are now gathering information. But let's leave it there for now. Thank you so much for speaking to us.
Before I go,
yes,
if you may let me.
Very briefly.
Briefly. We've also approached the Office of the Public Protector, because we believe that the Office of the Chief Justice cannot investigate itself sufficiently enough. We don't say they're not incapable, but there are certain things that we've also unearthed, not linked to the Office of the Chief Justice, but linked to the pilot project that was initially implemented, which need investigation themselves.
Let's talk more even about that as we get, really behind what exactly is going on here and unpack the story even further. But let's leave it there for now. Thank you so much for coming through this afternoon. That's Tebogo Khaas, Public Interest SA founder and chair, talking about that very worrying story. I'm sure you saw it in the Sunday Times yesterday.